Hey, everybody. Welcome to the show. Today, our topic is subject to transactions. We're getting into the weeds, talking about details of subject to transactions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to follow us. You can find us at Facebook. You can find us at YouTube. At YouTube specifically, you can find us at InRem Podcast. That's at InRem Podcast. Make sure to follow. Give us a like. We would appreciate it. With that, Sean, give us our legal update.
Thanks, Andy. So today what I want to do is talk about business purchases. So most of our clients are real estate investors and they're looking to purchase real property. However, I do have a number of clients that are looking to purchase businesses. And there are different ways to structure those business purchases. There's creative finance. There's different things that can be done, and I won't go into that today. But today what I want to do is focus on basically the two types of structures that you can have for purchasing a business. So the first type is to do an asset purchase agreement. And so what an asset purchase agreement is it's an agreement whereby you're going to go in and you're actually going to purchase the assets or specific assets of the business. So assuming you're purchasing the entire business, then you're purchasing all of the business's assets. So all of its goodwill, its website, its phone number, its tangible personal property. So, any type of furniture, fixtures, equipment, you're basically purchasing all of those assets and you're pulling those assets from the business into your business. So from that LLC or that corporation into your LLC and your corporation, that's who will own it. So the assets are owned by the business that you're buying the assets from. And then after the sale, you're going to own them. The other way to structure it is to do a membership interest purchase. So if the business is owned by just one or a few people, or even a number of people, all of who are willing to sell their ownership in the business, you can go in and do a membership purchase. Or if it's a corporation, then you would purchase all of the stock of the company. And so basically what you would do through a membership interest purchase or through a stock purchase is you would go in and basically purchase the ownership of the company, and you would then step in to the company as a going concern. And so you would then basically run the company as it presently stands, which includes its ownership of all of the assets, but it also includes all of the ongoing or current liabilities of the company. So if the company has debt, whether known or unknown, tangible or intangible, but any debt that's out there, you would basically step into that, and the company would still owe that. Now, you wouldn't personally be liable for that unless you actually, took over a guarantee or assumed the debt, but nevertheless, you step in to the business as a going concern with all of its assets, but with all of its liabilities. The advantage, though, of purchasing a membership interest is, let's say there's employees and there's payroll. In that case, you can basically keep those systems in place. The bank account can remain in place. You just have to change the signers. All of the payroll can remain in place. You don't have to, redo all of the payroll records and documentation and bank statements. Versus an asset purchase agreement, if you pull the employees over to your business, you have to do everything and set all of them up again with new payroll information. Find a payroll company, log all that information in. The other advantage of a membership interest purchase versus an asset purchase is, let's say you have companies that already have built-in payments coming to you. So your customers, your clients, they already have everything updated and scheduled, and there's regular payments being made by them. Well, if you step into the ownership of the company, well, those will continue. But if you're purchasing the assets, well, then you have to notify those customers and those companies and say, hey, look, I know you're making regular payments to me, but here's my updated bank account information, and here's what you need to do. And you have to change all of that then as part of the asset purchase. However, the downside to the membership interest purchase and the benefit of the asset purchase is what I was talking about with debt. If you purchase the assets, you can purchase them excluding the debt of the company, assuming you pay fair market value for the assets. So assuming you pay fair market value for the assets and it's not an insider type transaction, it's a bona fide arm's length transaction, and you purchase those assets, you don't have to assume the liabilities. And the liabilities can remain with the company that previously owned the assets. So that's the real advantage of the asset purchase, is purchasing the assets free of the liabilities. Obviously, if there's liens and encumbrances on those assets, then that's going to come with them. But if it's just unsecured debt of the company, you can leave that unsecured debt with the company, but pull the assets off and receive the assets.
I've always found it a little bit of a catch-22 on which approach to take, in that it seems a lot easier to just buy the membership interest or just buy the shares of the company and just walk into a going concern, right? There's no resetting up anything. You're just buying the ownership interest and walking in. That can be it's not that easy necessarily to do that transactionally, but easier, it seems, and a lot less involved than the asset purchase agreement. The problem is the liabilities that potentially come with the other liability is, one of tax liability, that of, whether the company you're buying has paid taxes. But so it seems like most buyers opt for the asset purchase idea. Uh, but with enough due diligence, that's what it requires a lot, right? A lot of due diligence going into the company and knowing the interest that you're doing. Transactionally, I don't know if you agree. I think it's a lot simpler.
Oh, a membership interest purchase or a stock purchase is much simpler than an asset purchase. It does require more due diligence, but it is easier on the back end to facilitate and arrange the transaction. Both can be done. An asset purchase, you still want to do your due diligence, but you're especially to determine whether there's liens, claims, encumbrances on any of the assets you're pulling over. But there's less of a concern there, like you said, of unpaid taxes and those types of things, because you're pulling the assets free of liabilities.
All right. Thank you for that. With that, we're going to get into our topic today. And today we are talking about subject to transactions, and not just at 30,000 feet. We wanted to get into the weeds on subject to transactions. Now, we understand the problem with that is that could mean we're really talking about a 3-week course, daily 3 weeks of day-to-day courses just to get through that. But today we're going to start getting into the weeds on what that looks like. And who better to talk with us about that than Scott Horne, Texas attorney. He's been with us before. He's been our guest before, and he is a wealth of knowledge. So welcome, Scott, and thank you for being with us today. How are you?
Doing great. How you guys? Happy New Year.
Yeah, happy New Year to you.
I guess we're a little bit past that now, aren't we?
Yeah, no, we're about a week, which is like what, an eternity in what we do. Well, we appreciate you being with us. So we know you've been with us, and I don't want to spend too much time on this, but tell our listeners a little bit about you and about Horne and Associates.
So similar to y'all, we're real estate and title attorneys. We're very narrowly focused on what we do, in that we do the creative finance world. We work with realtors and investors in the acquisition of properties and or the sale. We do your creative financing, be it seller finance, wraparound, subject to whatever it might entail in that regard, from disclosures to the actual closing process that is needed and necessary. From that perspective, we handle foreclosures through the Texas marketplace for our investor clients, and we do our landlord tenant representation and or when needed for our investor clients as well. And that is really pretty much what we do in our law firm. Now, we're also a title company. Our title company is called First Option Title. And what's fun about that is we got our direct operation set up about 3 weeks ago. So we're now a direct operating title office. We close transactions not only throughout the Texas marketplace, but we have the ability to close them nationally for our clients should they need to do so, whether it's mostly the residential world, but we do some commercial as well out there.
Now,
and so we play the real estate game in that world, at least.
You're also a real estate investor personally, correct?
We are, and that's what makes this job fun. I've been an investor now for some 30 years. We've been in the hard money lending, I don't know, 22 years or so of that time frame, and done a ton of deals. A lot of deals have been both cash acquisition, but we've done a ton of creative finance deals. To date, we've done, I'm guessing, nearly 7,700 transactions out there. And all that means is that for today, we get a chance to blend practical with the legal side. So we do walk the walk and talk the talk every day, and you know what your experience. And so all lawyers get, cubbyholed as sitting up in our ivory tower, pulling the strings, telling people what to do, when really they have no idea what they're doing. Well, the fun part is we do know what they're doing, which gives us the ability to help navigate their situation more appropriately and give them advice that I think is really needed in the marketplace right now. So yes, we're real estate investors. We're asset-based hard money lenders in the Texas marketplace. We do tax lending. We do transactional funding. We're home builders, nothing on a large scale. We've got our 3 new houses getting started right now, and we play that game.
So
that's who we are.
So getting into our topic today in subject to transactions, and I know you're not new to that game, and we're going to get into the weeds a little bit on this, but let's start out with the basics.
Weeds? Are we talking weeds or?
Yeah, well, you take your pick, probably all of them. So for our listeners who some of which might be seasoned professionals or maybe new to this game, let's start basic. So as somebody who's gotten their hands dirty and who also has the book knowledge as an attorney, so to speak, how would you define and what is a subject to transaction?
So great question. So initially I call a subject to transaction a silent assumption, where it's a transaction that is legally viable between a seller and the lender. In other words, we are not assuming the loan, meaning going to the mortgage company and taking personal liability for it, which rarely happens in today's marketplace. But rather, we are agreeing to make the payments on behalf of the seller towards their mortgage. And there's a market difference between agreeing to make their payments, because we're not taking, versus stepping into their shoes, assuming their responsibility, and of course they would get released from liability in an assumption type transaction. So the best way I describe it is it's a silent assumption where the lender is not involved in the transaction, so it's done without their permission.
I like that. So what are some examples of, now that we have an understanding of what a subject to transaction looks like, what are examples, and or maybe to phrase it another way, are there examples of loans, liens, or encumbrances that really don't work well or don't lend themselves to a subject to deal?
Oh gosh, as I know you guys, not all these mortgages out there, unless they're maybe a private mortgage, they're going to have the due on sale clause incorporated therein, which is what we have to navigate in our deal. But, the first one that comes to mind as being most problematic, a home but a one because of the short fuse that a reverse mortgage may have on it. And as you guys probably know, a reverse mortgage becomes due 12 months after the last spouse passes away or vacates the property. And so knowing that, you got to be able to navigate that appropriately. It doesn't mean we can't buy it subject to the debt, but we need to be prepared to pay off that debt when the mortgage is called due, because the great odds are it's going to be called due. And of course, the second one that comes to mind is a HELOC, a home equity line of credit, especially if that line of credit is still open. There's absolutely no way to allow someone to close a transaction subject to the debt where there's a I can go to the lender, get it closed, get it managed and modified in some format, and then move forward with it. So those are the two first ones that come to mind out there. Now, to go one step further, we can have some fun if you guys want to talk about this, the new query marketplace, where I keep hearing a lot of investors want to say that wrapping or taking subject to an FHA or a VA loan is somehow problematic today. And I have been hearing that now for weeks. I keep going, where in the world is this coming from? Because I can't find where it's coming from. Any chance you guys know where it's coming from?
No,
because, in my world,
yeah.
In the title world, in my opinion, it's always been the case that a title company will not issue title insurance on a sub-2 or a wrap if the underlying debt is an FHA, VA, or some type of a home equity loan. That just seems to have always been the rule of thumb that's out there. And so it is what it is. But just because that's in the title world doesn't necessarily mean that in the non-title world, we can't close those transactions. I think they're still viable to do. Yeah, we got the same issues of due on sale and those kind of items. And from there, it's the same risk factors, I think, as with any conventional lender. The due on sale clause. And if the deal is handled properly and handled correctly, recognizing that there is the due on sale and that they can be called due, if the seller and the buyer want to proceed forward, let them proceed forward with the transaction.
Yeah, and it's one of those things where, and as you explained, it's always been the title is leery of those and won't close those, wraps or subject to transactions when the underlying loan is FHA or VA. I've never seen, like you, I've never seen a publication or a legislative enactment that basically says it is, unlawful, illegal, criminal, or otherwise to, wrap one of those loans for various reasons. I think title companies have been leery of doing that, not wanting to get sideways with HUD or the FHA on those types of transactions. But I'm not aware of any law or prohibition as to those particular loans.
No, and I'm in your camp too, Sean. I haven't seen that out there. I have looked for it. I can't find it.
Right.
If somebody knows of some, rule or statute or paper that's been issued by them in this regard, let us know. We'd love to know those kind of things. I just haven't found it anywhere yet.
So I have a question, and it's not really it's not a loan. It's a lien or an encumbrance is what it's going to be. But what about a property that has an IRS tax lien? Can you purchase that subject to that IRS tax lien?
So your simple answer is yes. An IRS. Let me take you back a minute to our final question about FHA and HUD and whatnot and title companies. Here in Texas, I'm not sure how it is in the Arizona marketplace, but the title companies decided they wanted judgment liens, which by law do not attach to a homestead, removed. And that's a business decision that they're able to make, right? Pretty easy.
Yeah. Mhm.
Likewise, they got in bed here in Texas with the Attorney General's office and decided that, if the seller of a property has a AG child support lien out there, that child support lien has to get paid from the net proceeds, period. And again, that's a business decision. And so title companies are businesses. They can do, as a business, they can say, we're not going to issue title on X, Y, and Z if you don't do A, B, and C, or whatever it might be. It's just a business decision they get a chance to make. And if they do that with an FHA, VA, or home equity loan, it's a business call. I'm sure there's some good reasons behind it. Move on. You accept it, deal within the parameters, and go. So that just came to mind, guys, on that. Just wanted to bring that up a little bit as to why they may or may not do that. Now, IRS liens. So unfortunately, at least IRS liens in the Texas marketplace attach to all real property. And I'm going to make the assumption they attach to all real property in Arizona as well.
Yeah, it's federal law, so it's going to preempt.
Yeah. And, this sounds bad. Hope we don't have any IRS agents listening or anything of that nature out there. But keep in mind, who controls, though, is the federal government. They don't have their 87,000 new agents with their guns out there enforcing IRS liens or those kind of things. At least not that I know of.
Right.
And I've been doing this a daggum long time. And I have yet to see the IRS foreclose on an IRS lien. Now, it doesn't mean that they can't. They certainly have the right to do so.
Right.
And I don't know what their internal philosophy is. Maybe they believe that, the great majority, some great percentage of these things are going to be paid when the house is sold. Got it.
Mm-hmm.
But can we go in and buy the house subject to the IRS lien? No, let's say there's a first lien mortgage on the property to mortgage company, whatever. And there's this IRS lien. Well, if the investor or homeowner is going to buy that property subject to those liens, they need to realize it's a valid lien on the property.
Mm-hmm.
There may not be payments associated with it, but it's a valid lien. So if you wanted to go sell that property before that lien expires, you're going to have to find a way to pay that lien off in most instances.
Mm-hmm.
Would the IRS take a discount of that lien? The answer is maybe, if you're willing to go through all of the effort of doing that. I'm not sure what's worse, pulling all the teeth in my head or dealing with the IRS, but it's a pain in the rear to get them to respond to things because they just don't get in a hurry to do anything. And usually in our real estate transactions, we've got fairly short fuses out there. But, there's a time and place to look at all of this. Fun story, I actually closed a house subject to the existing debt. This has probably been 3-4 years ago now. And the seller had a $1.7 million IRS lien on the property. And this was a $250,000 property. And you look at that, and I'm sorry, anybody's radar is going to go up and go, are you kidding me? No, I'm not going to touch it. Well, and the fun story, I say fun story, the poor guy, he was owned a server farm. And the thieves cut through the roof, dropped down, stripped everything. And I'm not sure what all this happened and those kind of things, but it was obviously financially devastating to him in some regard. And I'm not sure why the liens were there. But we went ahead and bought the property because I knew those IRS liens were going to fall off in about 3 months. And if they were going to do something, you would think on a $1.7 million IRS lien, they're going to do something. They're going to go out and find assets. They're going to try to do what they want to find. They did nothing. And the liens went away. And so I think having a good understanding of how those work is one thing. And then number two is having the propensity to navigate those appropriately. Sometimes they may fall off soon, but what are they going to fall off in 6 or 8 years from now? What will the IRS change their position? They can. Will they come after everything and foreclose and everything? They can. And I think it's up to that individual investor to make that decision. Are they willing to do that? Because they're not going to be able to refinance the property. They're not going to be able to borrow money on it, unless they can get some private lender most likely to do it. You're not getting a title policy on it unless it's paid off most likely. And so I think it's a key of understanding what it is and then navigating it to the risk aversion of the individual investor that's out there. And as we all know, these investors are across the board in what they do, will do, and won't do.
Mm-hmm.
Have you attempted or had any success attempting to take a deal with the risk that, or knowing that there was an IRS tax lien, but believing you had some leverage to maybe negotiate a buyout or some reduced settlement with them in a sale? Or is just the worry of getting them on the phone too much to even ask to attempt that?
Trying to get them on the phone is next to impossible. They say they have a conduit for this, but I can't tell you whether it takes 30 days, 60 days, 90 days, 6 months. And then when you deliver paperwork to them, what the IRS usually wants to see is they want to see some type of an opinion of value from an appraisal perspective, a settlement statement. Show me a copy of the contract. And if the seller is getting money, they want that money to be allocated to the IRS lien. Now, the IRS lien may be more than the net proceeds they're receiving from the sale, but in those cases, they will accept that money and allow the seller to sell the house. They're not here to hold the seller hostage. It's just a time issue. And the question just becomes, does the seller and or their buyer have the time to deal with that? So often the sellers don't know that it exists. They know they owe money. They just don't know that the IRS has filed a federal tax lien. Even though they've been served that, by certified regular mail, it goes in the round basket and it's out of sight, out of mind. And so they go to closing and it's like, oops. Well, now they're under contract. They've only got 3 weeks before closing. And does their buyer want to sit around for 60, 90, 120 days while the IRS may or may not do that? And so often the buyers go away. But that's what I see from a title perspective so often. If the sellers can be more proactive, knowing this is out there, and get that process going in advance, I've seen the IRS release them. If the house is in a pre-foreclosure mechanism, they're not here and the seller is selling the home. And if they're making no money, the IRS is fine with that, so long as it's not a fraudulent transfer. But they'll do the same thing and release it, but it's just a timing issue. And unfortunately, it's the federal government, and they're not in a hurry like you or I are in putting deals together.
Let's talk about acquiring the property. If you leave it to 3 lawyers, we could talk about liens for the next 3 hours and put anybody to sleep. But let's get into
who needs CBD, right? You got us to do that for you.
Yeah. So in acquiring real property subject to existing loans, what are the different ways that you can go about doing that?
Well, I think there's basically 2. One is a true, what we would call a subject to transaction, which is where the property is deeded over to the buyer. And of course, I preach and teach, always protect that seller with some type of a deed of trust to secure performance in some format. Always take care of the seller, because if you don't do that, all you're going to do is buy a future lawsuit if you mess up somewhere. And I'm sorry, but you guys are expensive, okay? To hire to get out of that deal. And so the sub-2 transaction is an easy way of doing it. And of course, from there, every deal is a little bit different. In other words, does that seller, if they have equity, do they want cash? Are they willing to take a note in lieu of cash for their equity for a second lien position, let's say, which can be problematic to them in some format. They don't understand that sufficiently. Or do they want cash and a second lien? Or do they need walkaway money? So all those kind of things occur from the investment perspective when an investor is buying the house subject to the debt. Now, I see a lot of investors who think that they can just modify the terms of that existing mortgage. And of course, we got to tell them, guys, you ain't touching the existing mortgage. It's staying in place just like it is. And so if they want to buy it and modify the terms, they can do what we call a mirror wrap, which allows you to create a new note and deed of trust on the property. And it can be the same interest rate, the same loan balance, the same monthly payment, the same number of months for the term of the loan. But maybe they could put a balloon vehicle in there if that seller wants a 3-year balloon or a 5-year balloon or a 10-year balloon instead of letting the whole loan run its course. And when you run across more sophisticated sellers, you'll run into those scenarios. And now I'm kind of getting out of the subject to world a little bit, because that's kind of the same thing there. Is, of course, the next way to buy a house when there's an existing mortgage is a wraparound, and we can get into that scenario in a bit if you want to.
What about transactions where you're taking
So the two mechanisms.
Go ahead.
Go ahead.
Yeah. So
No, I was just going to say we can wrap stuff later.
Yeah. What about transactions where you're taking it subject to, but the conveyance is different than your typical fee simple transfer of real property? So by contract for deed, or in some states, maybe a land installment contract or an agreement for sale. Any issues there?
Well, in Texas, so first off, you want your client to understand what an executory contract is. And I think states are very different in how those are treated, especially here in Texas. So if a non-owner occupant is buying a property, can they buy it from a seller using an executory contract? And all that means is as I know you all know, but for the audience, is if the buyer pays the seller 100 payments of $1,000, they get a deed to the house. The problem is they don't have legal title, they have equitable title. And good luck explaining that in a really defined way. It's something in the middle between nothing and full legal title, right?
Right.
And oftentimes in that scenario, at least here in the Texas marketplace, if you buy a property using an executory contract, or let's just make it a contract for deed, other states I know call those land contracts. Am I right, in Arizona?
We call it agreement for sale here in Arizona.
Okay. So you got agreement for sale, we got contract for deeds, we have land contracts.
Yep, exactly.
Same thing, only different.
Yes, exactly.
Yeah. So, but it's how can the seller regain their ownership in the event of a termination? I used to write contract for deeds back in the day where if you're late in your payment, 5-day notice, it's done. You don't need 30 days or 60 days. And on a non-owner-occupied transaction, it's contract law here in Texas. You can negotiate whatever you want to negotiate. 1-day notice, 5-day notice, 30-day notice. It's whatever you come up with. Now, on the flip side of that argument, if you are a homeowner, so you're going to be a consumer now, our Texas property code doesn't make it illegal, as some people think they call it that. It just makes it almost impossible to navigate because the penalties are so stiff. First off, if there is an existing mortgage on the property in Texas, you cannot provide an executory contract to a consumer, not even available. If there is one, you're providing all sorts of things up front, surveys for free, and a free appraisal, a 14-day right of rescission. And if you do close the transaction and you did get permission from the lender to do so, that's fine. The buyer can request to be converted into a mortgage, and you must do so within 14 days, or it's a DTPA, a deceptive trade practice violation by statute. And so you just don't go that way with the consumer side here. All this lawyers just nix those on a consumer.
Well, that's interesting. So let's break that down a little bit, because I'm fascinated by this. So just in Arizona, we have agreements for sale, and it's a very basic statute. It does not differentiate between an investor, a consumer, owner occupied, non-owner occupied, none of that. And it basically says you can do it. And if there's a default and you have a loan servicer or a servicing agent in place, then you can do a non-judicial forfeiture, and then the timeframes depend on how much you've paid, right? So it could be as quick as 30 days, as long as 9 months, and a few dates in between, or timeframes in between. And that's it. So you can go and do a subject to with an agreement for sale, and then you can turn around and do your disposition with an agreement for sale or a lease with an option. But it sounds like in Texas, you can go in and do your acquisition with an agreement for sale all day long. The problem is, how do you dispose of that? How do you do your dispo, right?
You're not.
Yeah, right. Now, could you do a lease option on the disposition side to the consumer? So let's say I went in, did an agreement for sale in Texas, subject to existing loans. So I have an executory contract. And then I then decide, oh, well, I'm going to lease this property with an option to purchase to the consumer.
Answer is yes. And we'll talk about that in a moment.
Okay.
You know, I'm really jealous of you guys in Arizona. Y'all live in Nirvana. And prior to 2001, by the way, we could do all those things. It was awesome.
Right.
I did thousands of contract for deeds, you know, back prior to that. And done the right way, it was awesome. Mm-hmm. And you know the story. It only takes one person to screw up the whole batch. And that's really what happened in Texas is one person messed it up and they changed the laws for everybody. So, you know, we're always preaching to everybody, do things the right way, get good advice, don't be stupid. And you hope they'll listen along the way. Since 01, the contract for deeds went out. And then, of course, here in Texas, they started changing our lease option laws in 05, 07, and 09. And just made it a little bit harder each time, and then added familiar provisions out there. And obviously, we can buy a property using an executory contract from a seller as an investor. Mm-hmm. Can I sell a house using an executory contract to an investor? Yes, that's easy. Can I do a lease option to an investor or a non-owner occupant, whoever that might be? Mm-hmm. All of that's easy. And that's just, again, that's going to be contract law because our property code really doesn't get into that. Where our property code gets into is when you are dealing with a owner-occupant consumer is where the problems come from. And Texas has all sorts of funky rules and regulations. You've heard about the executory contract issues and what can happen on that. And then we have our lease option items where if they bought the project to the using a deed, can we do a lease option to the buyer? Simple answer is yes. But there may be limitations because the primary rule in Texas is a lease with an option to buy, where title is not delivered within 180 days, becomes an executory contract. Now we have a provision allows us to go up to 3 years in that scenario. But if there's existing mortgage on the property, it's getting permission from the lender, meeting provisions. And I think so often the investors probably miss one or two, if not all three of those items. And all they do is wind up shooting themselves in the foot. And it's not worth going there. It used to be if you have an executory contract with a consumer, and by the way, sometimes I've run across 3 or 4 of those just in the last couple of weeks with clients I'm helping on that were drafted before they changed our laws. What the investor didn't realize is when they changed the laws, nothing was grandfathered. And they never converted the borrower into a mortgage. And so if a consumer has been in a home for more than 48 months here in Texas, or made more than 48 monthly payments, either one, then you have to foreclose. And it's not just a rescission of the executory contract, which means just a written letter saying terminating the contract. Mm-hmm. So I find it so unique that in so many other states, you have the ability to utilize the executory contract agreement for sale, both in buying and selling, which really allows a lot of navigation issues. Now, let me make a comment, though, and this is me both as the lawyer and me as the investor talking a little bit. Although those things are legitimate in the marketplace, and there's a time and place for all of those to be incorporated. When you're buying a house from a seller, my position is I want to eliminate this seller from the repertoire. I want to get them out of the chain of title. Once they have conveyed that property to me through an executory contract, they no longer live in that house. It is no longer it's no longer their homestead, maybe. if it even was a homestead to start off with. And so if a judgment lien was to hit them, if they get into some type of a car wreck, something happens, if an IRS lien shows up out of nowhere, if X, Y, or Z happens, that's going to attach to the property, which means that seller now has to deal with that. And if that seller doesn't have the ability to deal with it financially, it's going to fall back on me. So if I in turn sold that property using either an executory contract or, let's say, a lease option agreement to my buyer, I'm going to have to honor their agreement regardless of why this additional lien showed up on the property out there. And so when I think through a deal like this, although there is a time and place for all these things to come into play, whenever it is possible to remove the seller from the chain of title through a subject to transaction, a wraparound mortgage, a mirror wraparound might be, I much prefer doing that so I don't have to deal with them. Now, the fun part about that is we have all these bad things in Texas with lease options and contract for deeds, etc. But the good part is we got great foreclosure laws. You guys not so great, not bad, just not as good as we are here in Texas. Because here in Texas, the way I get my sellers to agree to do a subject to transaction or a mirror wrap of some type is, hey guys, if I default, you can get me out of this property and foreclose typically faster than you can even do an eviction. It's only there's no notice to cure for an investor unless you put that in your paperwork. I know a lot of the states might have a 20 or 30-day notice to cure, even if you're non-owner occupied. In Texas, most of our deeds of trust waive all that. And so if you're an investor and you're 1 day late on the payment, that seller can accelerate the loan and post it and foreclose 21 days before the first Tuesday of the month. And so when they learn that, they go, oh, well, what does that cost? And it's like, it might cost $1,500 to foreclose here in Texas, but it's going to cost that to go evict somebody also. And they realize the time frames. It's just a mechanism to understand how you can market that and how they can benefit from doing that. But for the investor, I don't want to have to worry about some tail end Charlie IRS lien or judgment lien popping up on this property, 6 months later, a year later, 2 years later. That's going to directly affect me. I never expected or anticipated. So I think there's always when I look at these kind of things, guys, it's just, there's a time and place for everything. It's going to depend upon who is our seller, what's their situation. If they're really financially savvy and sophisticated, different ballgame, but most of our sellers aren't. They're usually in trouble in some format, financially, other things ongoing that are creating problems for them. And so I just like finding a way to get them out of the equation if possible. And yeah, we can play the games with executory contracts and lease options, and we can do sandwich lease options, where you do a lease option with the seller and do one to the back end buyer. And there's a lot of guys out there, we'll call them your gurus, who teach that also. And it doesn't mean that they're wrong, and again, as I said earlier, time and place for everything. It's just that there may be a better mechanism. And here in Texas, having such a short fuse on foreclosures can entice that seller to work with you differently than maybe they could at, let's say the Arizona marketplace. So there's a trade-off in everything you do sometimes in the game that we play, I think.
Scott, let's move and talk about the subject to transaction itself and the documents needed to really get that done properly. And some of our documents might differ slightly from state to state, but I think there's probably a lot of similarities. And I think what would be true in Texas is also true in Arizona, that the first document that you're starting with is the purchase contract.
Yep.
What are provisions in the purchase contract, when you think about it, with regard to a subject to transaction, that are just key and instrumental provisions that need to be in there? And maybe another way to look at this are provisions that you see maybe newbies miss and really screw up the deal.
Yeah. Well, the first one, so I always say that when you have a willing seller and a willing buyer, when you have full and complete disclosure, close the transaction, you have a good transaction. That's where I think realtors miss that part. They think that, it's just because there's an existing mortgage, you can't do it because it's illegal or whatever it might be. And they forget about the disclosure part, because these transactions are 90% disclosure and an understanding of the working mechanisms of creative finance. Putting together documentation to close the deal is pretty easy on the closing side, I think. There's some things I like to do differently than a lot of guys do. But on the contract, it is a disclosure of due on sale, number one, and making sure the parties actually understand what that means. A lot of people think that it's illegal to do it because of due on sale, and it's not. It's an option for the lender to call the loan due, not an obligation. And most of the time, lenders just want their money, but lenders walk around with blinders on all the time. And I'm not even sure if you guys have ever had the joy of talking to a lender who's called a loan due about this, but you may as well talk to the wall behind you. It's crazy. And secondly is the fact that the seller is not being released from liability until that loan is paid off. And of course, I always try to teach everybody, pay it off. It's like, tell them it's going to be paid off through attrition, through monthly payments. There's not going to be a guarantee it's paid off next week, next month, next year, 5 years, whatever. And, to that exact point, I had an email from a client from a deal I bought 5 years ago, emailed me. Now, they forgot that the house was in foreclosure. They forgot that we saved it from foreclosure, that we brought their loan current, that we've been paying their payments on time for 5 years, meaning their credit's been being, rectified over this time frame through their home mortgage. They're asking me why the loan's not already paid off. And I just had to remind them why it wasn't, shoot them back to their paperwork. And it's like, no one ever agreed to do that. But sellers have short-term memories based upon what their current needs are, and they forget what you did to help them out 2, 3, 4, 5 years ago. I always find that intriguing in this marketplace, and I'm sure it will never change. But those are my first two biggies are right there. And of course, the next one I would have is, I don't want that seller to communicate with the lender unless and if I'm in some type of a default. Don't interfere in contract, guys. You've sold the house. We've made our agreement. I like to use a limited power of attorney. And every state may have different POAs to be utilized. Here in Texas, we have a promulgated form we like to use. Arizona may be the same way. I like to use authorization forms so I can communicate with the lender if needed. But really, from the subject to perspective, those are the main things I want to get across in those items. But from there, the second tier, those are the primary tier issues, I think, that really need to be thought about. But I think a secondary tier are things such as, Mr. Seller, if you want to get financial information from the buyer, it's available, whether it's an investor buyer or a homeowner buyer. Now, they never ask that question, but I want them to know that it's available. And by the way, for instance, in my disclosures, that's denoted that if they want it, they can get it. We want to talk about how insurance will be handled. If they want to incorporate a loan servicer or not into the transaction. Does the buyer want to do a title search, or does the buyer want title insurance? I don't dictate to anybody what type of title evidence to get. I want to make sure they understand that they have options, and then they can pick and choose what level they want to go with. I don't know about y'all, but rarely do we get retained to be their attorney. We're just a closing agent. We're just an independent third-party closing agent, because the sellers or buyers never want to pay the additional fees to retain us to represent them per se. And that's okay, because I'm going to tell them the same thing either way, probably, if we walk through a transaction. But for me, it's just letting the parties understand that there are some things out there that they wish to elect to do that. They can do it because they don't know. Sellers are not investors. They're not realtors. They're not mortgage companies. And goodness gracious, they're not lawyers either. And they never consult a lawyer. They never consult a lender. They never consult anybody else. And they usually screw it up. But I want to make sure that they understand that to the nth degree. And so You know, I've heard for years, I did a disclosure package originally, and it's about 19 pages long when we're buying a property. And it's got all sorts of stuff in there because everything in there has happened at some point in time. You know, people show up, they just had a 3 martini lunch. You know, they come in their pajamas and they're still high from the night before. Oh my, I could go on and on and on about things that we see. I'm sure you guys experience the same thing too. We should write a book, you know. But it happens. And you want to make certain that both the buyer and seller go into these deals with their eyes wide open. You know, and so once we go through, and I did my contract disclosures in an extremely basic fashion intentionally. I go way back when this business wasn't even out there until really 2009, 2010. And it didn't really get exacerbated until the SAFE Act and Dodd-Frank started getting passed with more items. But I had a friendly competitor in another city here in Texas, and you know his disclosure page was 1 or 2 pages long in like 6-point font. You know, initial here, initial here, initial here. And I'm going, who the hell is going to read that? And being a lawyer and understanding how things work, especially in a courtroom, how things work, you know, I decided on mine, simple layman terms, individualistically. I have these big, bold titles, big, bold title blocks, you know, binding legal document, consult your attorney before signing every time, you know, ad nauseum. And I do that for a reason, so that if you ever do get drug into a courtroom, you know, did you sign here? Did you bother reading this? Did you consult an attorney? And by the 14th time they've done that, I think a jury kind of understands, got it. They didn't read anything. They didn't do anything. They just wanted to get this deal done. And so unlike how an investor thinks, I think being both the investor and the attorney, I put things together just a little bit different for that reason. And then one thing I did additional, because you understand that these investors, these sellers, the buyers, you know, again, 99% of the time, no lawyer, no realtor, no nobody. So I redisclose all this stuff in my closing package. I don't just do a traditional closing package. I go and add all this other junk in there, and it really is just more stuff of the same, but it's to reiterate the facts over and over again, so that if something does happen, don't ever accuse the somebody of misleading you. You had plenty of opportunity to review the paperwork, time, redisclosed again. And if you didn't do it, you know, caveat emptor, take your, no, buyer beware. You did it on your own risk. So that's a lot more than you wanted to hear in a short time frame, by the way, but the reasoning behind it and what you see out there in the marketplace.
So one of the things that has come up recently, and it's been there forever, but we're seeing enforcement of it more so now, is state overlooking state-specific disclosures or even rights of rescission that aren't ending up in these contracts. So you have investors that are going and pulling these forms from who knows where. They're using them in different states, and they're not properly consulting with an attorney licensed in that state who would know those laws. And then next thing you know, they're, you know, missing things. So for example, in Colorado, anytime a property's in default and you're going to be taking it subject to, you have to give a 3-day right of rescission and certain disclosures and things like that. What kind of disclosure requirements, if any, exist in Texas with respect to subject to transactions?
Well, let me jump into before I get to the Texas marketplace,
Yeah.
your Colorado law with the right of rescission. You know, I have heard just in the last 60 days that there's a lot of states that have foreclosure rescission or foreclosure rescue rules and regulations.
Yeah. And that's where Colorado is found. That rescission is on a foreclosure rescue statute.
Right. And where, you know, some may say you have a 3-day right of rescission. Some may have a 30-day right. Some may outlaw it completely. I don't know. And of course, you hear that. We don't have that necessarily here in Texas. You may not have that in Arizona, but some 20 states I hear have some form of that. So of course, I know that y'all do this. I know I try to do the same thing too. If I'm working with an out-of-state client, it's like I can walk you through the deal and get you 98% of the way there, but you got to talk to that knowledgeable real estate attorney in your area. If you're either the investor who's buying the house or you're selling it to a third party who's buying it, someone needs to talk to that knowledgeable real estate attorney, which is hard to find, unfortunately, in this industry, who has some knowledge base about that. And make certain that if there is some issue regarding foreclosure rescue, or it might be, you're able to ensure that you navigate that appropriately so you don't stub your toe somewhere along the way. So I think you need to do that. And then, of course, here in our wonderful Texas marketplace, as you said, there's always these rules and regulations that come into place that aren't in other states. So you've got an Arizona investor trying to play investor in Texas. You got a North Carolina investor trying to play in Texas. And they don't have the same rules and regulations, and see it constantly. They think they have a good contract and whatnot. And it's like, guys, here in Texas, we have what we call the underlying lien disclosure notice, which is a mandatory disclosure for any seller to provide a buyer, whether that buyer is a consumer or non-consumer, 7 days that they can rescind the contract for any reason. And it's mandatory. And we just recently got a new Texas finance code requirement that's a promulgated insurance paragraph, which all must be signed again prior to closing. If you don't sign these, there are problems. Here in Texas, again, because one investor out in beautiful El Paso, created all the problems for us. Now, every transaction where there's an existing mortgage in place, and the key is they don't define what the existing mortgage is. Is it a mortgage or is it an IRS lien? So since I don't know that answer, we're doing on anything that's being left in place, judgment lien, IRS lien, et cetera, just as a fail safe that's out there. But if you don't close in a law office or a title company, your transaction is not voidable, it's void. And that's pretty strong language, right?
Yeah.
That's the first one that you want everybody to understand. The second one is if you don't provide these new disclosures, and we've had the underlying lien disclosure notice for quite some time, but now they've put more teeth into it. Monetarily, it says now if you do not do it, the buyer can rescind the transaction and ask for all their money back. There used to be a reasonable rent scenario along the way. If the reasonable rent was $1,000 a month and their payment was $1,000 a month, you got nothing. But now they can come back and go, return your down payment, return your monthly payments. That means principal, interest, taxes, and insurance payments. Other damages are associated with that. And it's like, guys, do it right. Find the right people, talk to the right people. Don't be stupid. Unfortunately, they're still out there a little bit. And of course, here in Texas, the next one that came into play was if you do more than 3 transactions in a 12-month period like this, you have to be a licensed RMLO, and your company must be registered with the state of Texas, with the Savings and Loan Administration. So they did that just because there were some bad actors acting out there, and they're trying to weed that out. And I guess when you look at all of that combined, it's not a bad thing. It's really a good thing when understanding it, and it doesn't affect a transaction. In the thousands and thousands and thousands of these deals that I've closed, I've never had a buyer back out but for once with that underlying lien disclosure notice. It just doesn't happen. They want to buy a home. They want to be a homeowner, and you're affording them that mechanism. But just because you're doing that, there are unscrupulous attorneys out there. And I would never point that finger at you guys, but there are those guys out there who office around the courthouse who are looking for that investor who didn't do the right thing.
Right.
So they can go file that lawsuit and hunt money somewhere, somehow. So, you want people to understand that and to be cautious in how they're navigating this.
Well, Scott, we barely scratched the surface on subject 2. We're going to need like a mini series, like like Lonesome Dove mini series on what this is going to look like to get it all through. I've got so many more questions. So we'd love to have you back sometime and go through it. Where can our listeners find you online and get in touch with you?
You know, the problem, Andy, when you put me on here, you know, I can yap until the cows come home just because we deal with this kind of stuff. And it's fun with you guys because you actually understand this and you understand it across the board from all perspectives. But anyway, so they can look us up online at two different areas. One is at Horne and Associates PC. And I think it's horneandassociates.com is the actual website. Our other website is called theownerfinancenetwork.com, which is one of our training sites to help investors understand this business properly. And we really do try to put out quality information, help them understand how to do this. So you just don't go to the internet and believe everything you pull offline. But the OFN is a vertically integrated company that helps provide legal and title services for closing, a note pro service, which means if you need help to structure a transaction, you know, what shall be marketing at, interest rate, monthly payment, taxes, insurance, etc., whatever it might be. We have our loan processing services, our loan servicing underneath there. And then here in Texas, we have another division called OFN Lending, which is our wrap mortgage lending entity. So we actually substitute ourselves into the shoes of the lender, where we become the underwriter. We actually close the transaction like a mortgage company where the note and deed of trust is in our name, and we assign that back to the investor after closing. And what we're doing is we're substituting us into the middle of this to alleviate the liability from the investor, to ensure that we've met what we call the ATR rules, the ability to repay, and things of this nature on behalf of a borrower, and that the licensing issues are being handled appropriately so that the investor doesn't have to go through all of these licensing scenarios. And so OFN encompasses all of that under a one-stop shop to help the investor world have a place to go to get legitimate information along the way.
Well, that's great. And I know folks, because I follow him firsthand, but you can find Scott on Facebook, Instagram, TikTok. You're all over the place.
You know, and I visit those sites every day. You know, I got 5,000 of my friends on Facebook out there that I hardly ever open. I have a phenomenal business partner who takes care of everything in that regard for me, who's the pro at that. I'm just the information behind it.
Yeah, I was going to say, we can't get you off of TikTok, buddy.
I don't even know how to use TikTok, guys, but it's out there and I see it, and it's just the things you got to do. Hopefully the Chinese, you know, aren't going to come in and learn how to do and wrap around mortgages all of a sudden. What we're doing out there.
All right. Well, thank you, Scott Horne. We so appreciate you coming on. Hope to do it again soon because we got a lot more subject to cover.
Guys, it's always fun talking to you both, Andy and Sean. You guys have a great day, and we'll see y'all soon.
All right. We'll see you next time.
Goodbye.
All right, everybody. That is our show. Thanks for joining us. Make sure to be here with us next week. We're talking about the building blocks for a client-centric, focused real estate business. Make sure to follow us on YouTube. We'll see you next week.
Have a good day, everyone.